If you file for an order of protection, you'll have a hearing in front of a judge to give you a chance to prove that the abuse happened and why you need the order. Testifying in a domestic violence case can be very stressful. This short video will help you avoid some common pitfalls when you're giving testimony in the courtroom. Rule A. In your testimony, establish the physical violence first before anything else. The judge may ask you specific questions, but it's more likely the judge will ask a broad question such as, "Why are you here today?" or "Tell me what happened." You'll need to be prepared to testify about what happened. When you're testifying, it's tempting to talk about other issues like your spouse's cheating or not supporting the kids. Resist the temptation to do that. Focus on the domestic violence. Other issues like custody or child support might also be addressed at the hearing, but they will definitely not be addressed if you don't prove that the violence happened. Practice your testimony before the hearing, and then practice it again. Rule B. Focus on the most recent abuse. This will show the judge that the abuse was recent and is likely to continue. Rule C. When you're testifying about the abuse, use specific action words. So instead of saying, "She came at me," be more specific. Instead, you might say, "He threw a vase at my head and knocked over a table," or "She stood over me with her fist clenched like she was going to hit me." Also include details about any injuries you received from the abuse. Rule 2. Prove the abuse with evidence. Your abuser may lie about what happened. It's your job to prove that the abuse did happen. Think of anything you can to back up your testimony. The most common and effective types of evidence include photos of injuries, medical records, videos or audio recordings, and testimony of other witnesses, especially those who were there when the abuse took place. If the evidence is on your phone, print photos of it or move it to an audio tape. The judge will not look at your phone. Rule 3. Keep it simple. Avoid details that don't have to do with the violence. The judge doesn't need to know everything that went on that day unless it's relevant to the abuse. For example, if the argument started about money, the judge doesn't need to know all the details about the bills or amounts of money involved. It's enough to say, "We were arguing about money." However, this rule does not apply to details about the abuse. It is very important the judge know those details. Rule 4. Tell the truth, but not more than you need to. You don't need to volunteer information that you were not asked about and that's not relevant to the abuse. Rule 5. Stay calm. Although someone who's been abused has every right to be extremely upset, the courtroom is not a place for showing anger. It's okay to cry, but don't yell, curse, roll your eyes, or be sarcastic or rude. If your abuser acts out in court, it will bolster your story. The abuser or the abuser's attorney will have the opportunity to ask you questions. He or she will probably try to make it look like you got the details wrong, or that you lied about something, or that you were at fault. Take deep breaths and respond as calmly as possible. Practice how you'll respond when this happens.